Hello, everyone, and thank you for joining us for today's presentation as part of the Industry Insight webinar series. The topic this time is the duty of technology competence, what it means for your practice. Speaking today will be Robert Ambrogi. Robert is a lawyer and journalist who has been writing and speaking about legal technology and the internet for 2 decades. He writes the award-winning blog Law Sites and is a technology columnist for Above the Law, ABA Journal, and Law Practice Magazine. He co-hosts the long-running legal podcast Lawyer to Lawyer, as well as the podcast Law Technology Now, both available through the Legal Talk Network. 1980 graduate of Boston College Law School, he is a fellow of the College of Law Practice Management and immediate past president of the Massachusetts Bar Foundation. In 2011, Bob was named to the inaugural Fast Case 50, honoring the law's smartest, most courageous innovators, techies, visionaries, and leaders. In 2017, he received the Yankee Quill Award for Journalism from the Academy of New England Journalists. The presentation today will be followed by a Q&A. Please enter your questions into the question box in the webinar panel on the right side of your screen. All questions will be addressed at the end of the presentation. We're recording this webinar and we'll be sending a video and a follow-up email in a few days. We'll also post a video on our blog at www.lawtechnologytoday.org. Thank you all for joining us. We'll now begin the webinar.
Thank you, Austin, and thanks to the Legal Technology Resource Center for hosting today's webinar, and to Case One Practice Management Platform for sponsoring today's seminar. You can find out more about them at case.one. Way back when I went to law school, this was essentially the state of the art of legal technology. I wonder how many of you out there have ever used one of these, and there may be some of you out there who've never even seen one of these. But at the time that I got out of law school, it was really cool because until then, when you were working on a typewriter and you made a mistake on the typewriter, you had to roll out the sheet of paper, get out this little bottle of whiteout and clean it up, dab a little whiteout on, wait for it to dry, roll it back down, and start to type again. And when IBM came out with this IBM Selectric 2 typewriter, it had this really cool function, which was that you could basically just backspace and it would correct what you had just done. And man, I thought that was really cool technology back then. But technology has changed an awful lot in the years that I've been a lawyer, and I'm glad to say I've moved on from the typewriter, and I've done everything I can to try and keep current with and keep up with technology. But not every lawyer has. Let me tell you quickly about a lawyer in Delaware who was representing a defendant in a matter in which he was served with an e-discovery request to produce certain data in a spreadsheet format. First time he tried to do it, he bungled it pretty badly, and the plaintiff went to the court and asked for a motion to compel, asked for an order to compel, and got the order. And the defendant's lawyer tried again. He bungled it a second time. They were back in court again. Third time, this time the court ordered him to hire an IT consultant. Apparently he must not have gotten a very good IT consultant because he bungled it the third time as well. And this time the plaintiff filed motion for sanctions, and the court held a hearing on that motion for sanctions. And the lawyer came into court and stood before the judge, and this is what he said. He said, "I have to confess to this court that I am not computer literate. I have not found presence in the cybernetic revolution. I need a secretary to help me turn on the computer. This was out of my bailiwick." Well, as you can imagine, the judge was not too sympathetic to that argument, and the court ruled that professed technological incompetence is not an excuse for discovery misconduct. And in fact, the court went on to impose pretty severe sanctions in this case, including attorney's fees and adverse inference against this lawyer's client on the matters on which discovery had been sought. Now, this is kind of an extreme case, but you just have to look at the news lately to see any number of examples of lawyers messing up on technology. These are all stories from just basically the last month or so. One in which a Wilmer attorney inadvertently leaked Pepsi client data secrets to the Wall Street Journal. And here you have a lawyer at one of the top firms in the country with a major client emailing highly confidential information to colleagues, to other attorneys in a case, and somehow managed to add a Wall Street Journal reporter to the CC line. And of course, that Wall Street Journal reporter did what any self-respecting reporter would do and wrote about the information that was leaked. Another, I think, really surprising one is DOJ redaction flub may underline LIBOR case. Again, here you have attorneys at the Department of Justice, the nation's law firms, the cream of the crop of the legal profession, filed a document in federal court that contained an attachment that in that attachment there was, again, highly confidential information that was supposed to be redacted. They didn't redact it right. And once again, a reporter who was following this case happened to download the document and did a copy and paste from the supposedly redacted document into a Word document, and suddenly all the supposedly redacted information was visible in the Word document. This time the reporter notified the DOJ and they fixed the memorandum, and it was properly filed fairly quickly. But these just kind of, and there are more stories here. I won't go into all of them in the interest of time. But these, I think, illustrate why perhaps it's important that there be a duty of technology competence for lawyers. So let me talk a little bit about what this duty is, where it came from, and what it means. Way back in 2009, I think it was, the American Bar Association appointed something called the Commission on 2020 Ethics, the Ethics Commission on 2020, which was appointed essentially to look at the ABA model rules of professional conduct in light of the developments in technology over the last couple of decades, really, and in light of changes to law practice and in light of globalization of law practice. And that 2020 commission spent a couple of years looking at this issue, ended up making a number of recommendations about how the model rules should be revised to account for these changes in technology. The one we're here to talk about today is the change to ABA Model Rule 1.1. And of course, 1.1 is the model rule on competence. It basically just says a lawyer shall provide competent representation to a client, and a competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. And in comment 8 to that, to Model Rule 1.1, which talks about a lawyer's duty to keep abreast of changes in the law and its practice, the 2020 Commission recommended, and the ABA adopted in 2012, the insertion of this fairly simple phrase, including the benefits and risks associated with relevant technology. And so, in other words, a lawyer has a duty not just to keep up with the law and its practice, but to keep up with the benefits and risks associated with relevant technology. Of course, a model rule doesn't mean anything in terms of its impact on practicing lawyers unless state regulatory bodies adopt that rule. So far, 28 states have adopted comment 8. I keep, if you're interested in following this, I keep tabs on it at my blog at lawsitesblog.com. I've been following the states as they adopt this, and we're up to 28 states right now. But what does this really mean? It's fair to say that in order to understand the benefits and risks associated with relevant technology, you need to at least understand something about the technology, or maybe at least know what you don't know. But how far does that go? Well, the first real answer to that we got came from California. In 2015, the California Bar issued this opinion, 2015-193, that specifically talks about this duty of technology competence. And if you had been paying attention a moment ago to my map of the states, you might have noticed that California is not one of the states that's formally adopted the change to Model Rule 1.1, but this opinion does expressly refer to the ABA model rule and discuss the ABA rule. and basically in saying that several things that are pretty significant, I think. What they did in this case is they actually sort of concocted a hypothetical, and they used an e-discovery scenario. And again, I think it's significant that you'll see as we talk about this, some of the cases and other issues that have come down so far have involved e-discovery, and I think that kind of makes sense because e-discovery tends to be one of the more technologically complex and complicated areas of law practice, both because of the challenges of collecting data, understanding how data is stored, but then also the challenges of reviewing that data once you've collected it. Understanding technology is really critical to both aspects of that. And this opinion, what immediately struck me about this opinion was that basically it says, I've highlighted the text here, that in today's technological world, almost every litigation matter potentially involves e-discovery. And they're making the point here that e-discovery, I think a lot of lawyers think of e-discovery as a somewhat almost esoteric field, that there are specialists in e-discovery, and we will leave this to the specialists. But this opinion is making the point that almost every lawyer who sets foot in a courtroom has to have at least a basic familiarity with some of the issues around e-discovery. You don't have to be an expert, but you have to, again, know enough to know what you don't know. So what they do is they say there's sort of not a bright line rule here for what defines technological competence in an e-discovery matter, but they do say that at the outset of any case in where e-discovery issue might arise, a lawyer has a duty to assess what those issues might be and the likelihood that there will in fact be e-discovery. And then if e-discovery is likely, then the lawyer has a duty to assess his or her own e-discovery skills and resources as part of the attorney's duty to provide the client with competent representation. So there again, it's kind of a bit of a catch-22 in the sense that you don't necessarily, they're not saying you have to be an expert in e-discovery, but you do have to know enough about e-discovery and what it entails to know whether there are going to be issues in the case and whether this is something that's going to have to be addressed in the course of the case. They actually list out what it might mean for a lawyer to be competent in e-discovery. They offered these 9 descriptions of tasks that a lawyer who's competent in e-discovery should be able to perform. I won't go through all of these. You can read the slides, but identify custodians of potentially relevant ESI, engage in competent and meaningful meet and confer with opposing counsel, perform data searches, collect responsive ESI, and ESI is electronically stored information, in a manner that preserves its integrity. These are pretty sophisticated tasks, and they're saying an attorney, that's what competence might be for an attorney in an e-discovery matter. But the key thing that they say in this opinion is that you can effectively contract out your competence in the sense that if you are not an expert in e-discovery, then it's perfectly appropriate to associate in the matter with somebody who is. It could be an outside attorney, could be a vendor, could be another attorney in your firm, or they say even your client, if your client happens to have that competence. But again, here's another catch-22 in my mind, because as long as you're the supervising attorney in that case, you continue to have a duty to maintain and to supervise that case, to maintain overall responsibility for the case and for the work done by the vendor or whatever the third-party expert is in the case. And here again, it seems to me that you need to have a degree of competence in the technology to be able to supervise. You can't supervise what you don't understand. This opinion also makes it clear that you have a duty. Of course, a lawyer always has a duty to assert and protect the attorney-client privilege in every matter. And here again, even if you're contracting out or bringing in somebody else to focus on the technology parts that you're not competent in, you maintain that duty of overall supervision and protection of confidences. So again, you're going to have to know enough about the technology to be able to do that. Another key ethics opinion that came down this year came from the ABA, and this is actually the first ABA sort of official pronouncement on this duty of competence, formal opinion 477. And this updates a 1999 opinion. Back in 1999, when I think you could kind of say email was still relatively new in the legal profession, the ABA issued an opinion saying that lawyers do not have to encrypt email. This opinion revisits that in light of changes to practice, changes to what we understand about cybersecurity, but also specifically in light of the changes to the model rules, particularly the model rule 1.1, and also some changes to 1.6 regarding client confidences. And here they are saying that in some circumstances, in fact, circumstances would warrant using particularly strong protective measures such as encryption. And here again, similar to the California case, they say at the outset of every matter, a lawyer should undergo a fact-based analysis that includes, evaluating the sensitivity of the information that will be at play in the matter, the likelihood of disclosure if some kinds of stricter safeguards are not employed, the cost of employing safeguards is a factor to consider, the difficulty is a factor, and the extent to which the safeguards adversely affect a lawyer's ability. So there's no bright line here. There's not a yes or no, you need to encrypt or use stricter security, but you need to be undergoing this analysis. The opinion also says that in terms of the sort of the skill set that a lawyer should have to go through this analysis, the lawyer has to understand the nature of the threat, has to understand how client confidential information is transmitted, where it is stored, understand and use reasonable electronic security measures, determine how electronic communications about client matters should be protected, label client confidential information, train lawyers and non-lawyer assistants in technology and information security, conduct due diligence on vendors providing communication technology. So once again, what this ethics opinion is saying is you have to have, in order to be representing a client competently, again, you don't have to be a cybersecurity expert, but you have to have a minimum level of familiarity with this technology to be able to make these kinds of assessments. And I query how many lawyers out there really do, number two, understand how client confidential information is transmitted and where it is stored. Sure, how many lawyers do understand that? Again, you can bring in third parties to help you with that, and that's perfectly appropriate to have consultants and others even at your firm who can help you understand these questions. And here again, there's a duty to preserve client competences, of course, is the key duty here. But something this opinion says is that in a number of cases, you really should sit down with the client and discuss with the client the security measures that may be warranted, and that the lawyer and the client should decide together on what sorts of measures should be taken, or what method of transmission of documents should be used, down to the level of, if the client wants paper, then they get paper. This is it's an important discussion to have in any case, because you often just don't know. In some cases, you just don't know where the client is getting email. I think there's a lot of assumption often that a number of that people have their own email accounts, their own private computers. But obviously, if you're representing a client, say a family matter, that client may be sharing that computer with other people in his or her household, including a spouse. If the client, if it's a workplace matter, or even if it's not a workplace matter, if the client only has email at work, employers have a right to go into that email, and so you may not want to be using that client's email account. So these are important questions to be asking and discussing. So a couple of points on why we should care about this, and I hope it's a little bit obvious that maybe the first reason is, well, because you can get in trouble. We are talking about ethical rules here. We're talking about rules of professional conduct, and you want to be protecting your client, and you want to be protecting yourself, of course. I only know of one disciplinary matter right out of Massachusetts, where I'm located, in which a lawyer was expressly disciplined for sort of technological incompetence. But I think any of us who've been paying attention will know that there have been any number of ethics opinions over the last few years in which if lawyers weren't incompetent in technology, they were stupid on technology. They did some embarrassing or stupid things. Just a number of stupid Facebook tricks that lawyers have engaged in over the last couple of years could fill a book, I think. You want to be mindful of the fact that this is a duty, a professional responsibility of yours as a lawyer to maintain competence or at least go through these analyses in pertinent cases. There have been other court cases. There haven't been too many cases yet, but there have been a few court cases that emphasize this. This is one in which the court, again, it was an evidence issue here in which a recording, a video recording was shown to used in evidence without audio in it. When the jury asked to see the video during deliberations, apparently unaware to the judge and at least some of the counsel in the case, the video actually had audio accompanying it that had not been put into into evidence. So when the video was shown to the jury, during their deliberations, they picked up on this audio that was not in evidence. The majority opinion in this case essentially just said it was not material to the outcome of the case, and so they did not overturn the verdict. But in this concurring opinion, the judge went to great length to talk about the importance of lawyers understanding issues such as metadata in technology, and again, specifically cited the ABA model rule to talk about that. Another case, another e-discovery case, I said earlier, a number of these come out of the e-discovery area. This one actually cited that California ethics opinion we talked about before, but here again, it was a case in which the counsel for the defendants really messed up big time in terms of preserving evidence. And, as you know, when there's even a reason to suspect that there might be litigation upcoming, you have a duty to preserve potentially relevant electronically stored information and implement a legal hold. In this case, the lawyers had really messed it up big time and resulted in some significant evidence in the case being destroyed. And here again, the court imposed sanctions of all attorneys' fees and costs incurred in discovery. And again, as in that other case I mentioned earlier, recommended an adverse inference instruction to the jury should the matter go to trial. So you can really cause some problems for your client and yourself if you're not mindful of the technology. And then, there's just a much more sort of practical reason to be understanding and competent in technology, and that is simply the fact that technology, the law practice has changed dramatically because of technology and is continuing to change dramatically at a very, very rapid rate. I try and keep up with this stuff, not quite for a living, but certainly as a hobby on my blog. I follow technology very closely, and I find it difficult to keep up with everything that's happening in this area. This is just a chart I will admit I've borrowed from David Curl at Thomson Reuters, an analyst at Thomson Reuters, and he uses this in a presentation he gives. But it just kind of gives you a map, a kind of a visual map, and it's not at all complete, but of the many ways in which technology is permeating the legal profession, in just about every area of law. practice management, legal research, case management, online dispute resolution, contract management, document automation, e-discovery, legal education, legal litigation funding, business development. In all of these areas, there are unique products designed to help lawyers at what they do and enhance their ability to do that. But more and more understanding technology and being able to use technology is integral to the practice of law. And of course, we're at a time when there's a rapid change in a number of areas. We're seeing artificial intelligence, of course, has become the big buzzword, and some say it's being overhyped right now. But in fact, artificial intelligence is finding real application in law. Maybe it kind of started in the e-discovery area. The things like if you ever use predictive coding or technology-assisted review in an e-discovery matter, those are machine learning technologies or a kind of artificial intelligence. But now we're seeing artificial intelligence go off into areas as diverse as legal research, legal billing, and any number of other areas in law with actual application, not just hype or talk. Blockchain is another area, of course, where there's a ton of development, a ton of talk and attention being given right now. Some are saying that blockchain is going to be even more significant than AI in its effect on the legal profession going forward. Blockchain holds promises for really changing the way that we conduct transactions, that we identify digital identities, execute contracts around using blockchain to execute smart contracts. And we're also seeing a lot in terms of bots and online dispute resolution, any number of other areas, all of which kind of lead to the question of your own future as a lawyer, your own employability, being able to understand these technologies, use these technologies, have a good basis or foundation for what they do, is key to your own employability, your own job security. And it's also key to representing the client. I mean, ultimately, what we're talking about here is it's all about the client. It's all about representing the client. And of course, being able to master technology, being able to use technology is critical to being able to deliver your services more efficiently, to being able to deliver your services at lower cost, and even being able to deliver your services better. I think there's often a perception in the legal field that lawyers are the gold standard, that nobody and no thing can do a better job for a client than a lawyer. In fact, that's not true. There are, in fact, instances in which technology can do better than lawyers. I would refer back to something I just mentioned. The area of using technology-assisted review and e-discovery is a perfect example of that, where if you have hundreds of thousands of documents to review in a matter, lawyers can't physically do it within the timetable of an average of a normal litigation. Technology-assisted review enables them to do that more efficiently, but even more importantly, it's been shown in study after study that computer algorithms can often deliver more precise results, more accurate results than lawyers do, than human review or manual review would do. And there are other examples as well. Due diligence contract review in the M&A setting is another one where machines can actually do better than humans at finding relevant language out of huge sets of contracts. So it's useful to keep in mind that technology isn't just about being more efficient, but it's in some cases making you even better as a lawyer. So all of this kind of begs the question of how do you get and stay competent? There have been a number of developments in that I think are in that area that are worth mentioning, and I'll talk about them quickly. I know we're shooting for about 30 minutes here, and we're at about 30 minutes, so I'm going to go through this last part a little bit quickly, and we do want to leave some time for questions once I'm done. But a few developments in this area. One, of course, is mandatory technology training. Last year, the Florida bar became the first state to require mandatory tech CLE for lawyers. The rule requires that lawyers in Florida complete 3 hours of CLE every 3 years in approved technology programs. Florida is the only state that has adopted this requirement so far, but I'm quite willing to predict that any number of additional states will eventually do this, because it seems to go hand in hand with adopting the duty of technology competence. Another example of how lawyers can are staying technologically competent is, I'm not sure if you're all able to hear me. I'm getting messages telling me there's an audio problem. The ProCertus Legal Tech Assessment. This was a company started by Casey Flaherty. Some of you may have heard of him. He was the former general counsel at Kia Motors. And when he was at Kia, he imposed sort of a tech competency test on outside law firms that he wanted them to go through before he would contract with them to work for his company. And this is really a very core competency, just to show basic skills in Word, Excel, PDF. He's turned that into a company, a business, and the tech assessment, there are now any number of in-house legal departments that are using this tech assessment with their outside law firms. Are you able to hear me?
You're cutting out a little bit.
I'm getting weird messages from my. I'm sorry, I'm cutting out. I keep getting messages that it's telling me I'm getting disconnected from GoToMeeting here, GoToWebinar. But I'll carry on and let me know if you lose me. But this is now being offered.
Numerous people saying they can hear you fairly well, so sorry to interrupt. Okay, but I think you're okay. Yep. Okay,
all right. So this is being offered now as a technology training. It's basically a product, but what it does is both assesses skills and provides training in skills in which the person taking the assessment shows weaknesses. And again, these are not high-end legal technology skills so much as sort of basic skills that show a lawyer knows how to use Excel and use Word and use PDF. Probably would have helped if that DOJ lawyer had taken this test before they tried to redact a document and file it in federal court. Some other developments. Dan Lina, director of the Center for Legal Services Innovation at Michigan State University College of Law, has done a couple of things lately. Back in August, I think it was, he launched something called the Law Firm Innovation Index, in which he's essentially rating law schools, indexing law firms rather by how innovative they are, how well they use technology to deliver legal services, how innovative they are in using technology to deliver their legal services. And then he has just, a week or two ago, launched a similar index for law schools. Initially, he's only got, I think it's 38 law schools in this index. You can find this online if you just Google Law Firm Innovation Index and Law School Innovation Index. But he plans eventually to rate every law school in the country on basically how well they are preparing their students to practice law in the 21st century, and particularly to use technology and other entrepreneurial methods. They rate schools on whether they have courses on things like project management, entrepreneurial lawyering, computational law, empirical methods, data analytics, and the list goes on. And also, identifies schools that have very specific kinds of law and different law and fill in the blank courses, law and e-discovery, say, or law and artificial intelligence, courses. And then also, just in the last couple of weeks, Suffolk Law School has launched a online certificate program for practicing lawyers, and it's a certificate program in innovation and legal technology. And there are 6 courses. It's going to launch this summer. And lawyers who complete all 6 courses will receive a certificate from Suffolk Law School in legal innovation and technology. You don't have to take all 6 courses, but if you do all 6, you get the certificate. And these are courses in topics such as legal operations, process improvement, and legal project management, the business of delivering legal services, design thinking for legal professionals, and more. And you can check that out at Suffolk Law School. And then, of course, a number of lawyers are kind of taking matters in their own hands and just kind of learning how to use technology directly in their practices. A number of lawyers, this is shows a book written by a lawyer named William Hahn, also does a blog, but he literally quit law and learned to code and now works full-time as a coder. But of course, number of lawyers are learning to code, not because they want to quit law, but because they want to understand something about what, better understand how technology can be practically used in their own practices or to improve their own processes or to better serve their clients. And even if you don't want to become a coder, learning something about coding helps you understand the possibilities and the limits of software and what can be done and can be useful to do. Finally, I think I like to make the point that technology, learning about technology, I go back to that typewriter example. For me, it's been a long course of continuing to learn about technology, to read about technology, to try different technologies. And I think competence really comes down for everybody to a little bit of a do-it-yourself model. You need to get your hands dirty a little bit with it. You have to try different tools, see how they work, explore different technologies, and see what's going to work best for your practice.